Well, as Mike said, my name is Jason Stone. I am a transactional lawyer over at the Davis Brown Law Firm here in Des Moines. I've been practicing for about a decade. I represent some very large clients and I represent some very small clients that are just getting off the ground. One of the things I kind of wanted to do is first give a self-plug here for the Davis Brown Law Firm. One of the things that we've come up with recently is called the Startup Launchpad. The Startup Launchpad is a service of the Davis Brown Law Firm. It's not separate and distinct from the Davis Brown Law Firm. It was just a way for us to try to take some knowledge that we had in-house and try to take our service delivery model and make it more efficient so that we could better serve our clients, particularly those that don't have deep wallets and don't have a lot of history and experience. And so we set up what is the Startup Launchpad. The Startup Launchpad has a number of things on it. I think Mike may have blogged about it a couple times. One of the things that we put up on the Startup Launchpad, which by the way is principally centered on a website, are some free educational materials. Again, trying to keep costs down for our clients. We realize that as lawyers we produce content on a very regular basis, and so we kind of combed through that content and picked out things that we thought would be useful for our clients. Memos that we may have written in the past or presentations that we've given in the past to provide tips for people. For example, we have a chart on choice of entity, which goes through all the pluses and minuses of each type of entity that's available in the state of Iowa. And we have questions you should ask in an interview and questions you shouldn't ask in an interview, and many, many other things, all available on the website for download for our clients at any time. We also offer free monthly office hours. It's, again, limited to our clients. It's one of the things that we've kind of encountered as a misunderstanding about the Launchpad, since it's primarily centered on a website. People think it looks like and works like LegalZoom. Well, it doesn't. It's just an extension of our basic hand-holding. We meet with all our clients. We talk to all our clients. All our clients have access to how many attorneys do we have now, Mike? 70, 80 attorneys in various areas. And one of the ways that we have that touch is through monthly office hours, where we meet with our clients, learn about their business, talk to them, and see what's going on. We also tried to kind of speed up the service delivery process quite a bit. We had heard from our clients and generally in the community that lawyers are slow. Business moves very quickly today, and lawyers tended not to keep up with that. And so we wanted to find a way to kind of speed our service delivery. And what we did is we took a lot of documents and spent a lot of time, without charging any clients, automating the production of those documents so that we could move a little quicker on first draft generation to keep the deal moving and to keep the business clients happy. And we instituted a number of other efficiencies within the system. That automation and those efficiencies actually allowed us to reduce our prices, which was kind of rare, but we did. We flattened them. Basically, we allowed some of that efficiency to pass through to our clients. We take some of the efficiency and we pump it back into the local entrepreneurial community, and we keep some ourselves. There is a broad scope of service on there. Again, this is just a way for us to communicate with our existing clients. There's on the website, we provide services on setting up a new business, entering into an employment agreement, securities law, intellectual property. But even if you're not, finding what you need on the website, you have direct access to those 70 or so attorneys, whether it's international law or criminal law or whatever the case may be. We probably have somebody that does it. We also kind of, when we were talking to our clients, heard a lot of complaining legitimately that because startups don't have a lot of money, to the extent that lawyers in law firms were servicing them, the client would come in and meet with a partner who has a lot of experience and knowledge and a good name, but then they'd push the work down to brand new attorneys. And in reality, what we think you're buying when you go to an attorney is the knowledge and experience that's built up over time. And so we didn't think it was really fair for our clients to get pushed down there, so we tried to find a way to push it back up. The automation and the efficiencies we built in really allows us to do that. Now, not all the services are always offered by partners, but in most cases they are, and we certainly strive for that. I guess the final thing I'll say about it is we launched May 19th of last year, we've been working on a redesign of the website, which should launch very quickly. It doesn't do a lot more than what we did before, but it's a lot prettier and it's easier to navigate and use. So be on the lookout for that. Okay, what Mike really asked me to talk about today, as he mentioned, were contracts. And I immediately said yes, because it was Mike asking me, but then I sat down and I said, well, what can I talk about? This is actually a very broad topic. It touches many, many aspects of the business world, and it's kind of difficult to distill into a presentation that could be as short as a half hour. But what I thought we'd do is we just kind of go through a few high-level points, and then at the end of the presentation I might highlight a few particular situations, and I'll try to integrate some stories throughout. But obviously the first thing when you're thinking about a business contract is you need to know when you've entered into a contract. And I think Mike alluded to that. I mean, if we know, if we're dealing with a 50-page document that's in writing and signed by both parties, clearly that's a contract. But what else is a contract? Just curious, what do you guys think a contract is? Anybody have a definition that they'd be willing to throw out? If you don't, I'm going to make Mike do it. There you go.
On the bank side, a commitment letter is a contract.
Yeah, a commitment letter can be a contract. I mean, fundamentally, what a contract is simply a promise to do something in the future that is enforceable under the law. And as we've mentioned, and as you know, that can be a writing, but can also be something else. There's a number of situations in which you cannot have a writing, you cannot even intend, in some respects, to have a contract, but be forced under the law to be bound by contractual duties. One of those areas is reliance. So, for example, let's say I get burned out with the law and I want to do something that's much more hands-on and simple. So I decide that I'm going to deliver FedEx packages. That seems pretty easy. I'll just get a truck, drive around. That'll be a lot less stressful during the day, hopefully, but maybe not. So I call up FedEx and I say, hey, I'm interested in this. They say, that's great. Why don't you take this training? I take this training, talk to them again, and they say, that's great. We really think you'd be a good member of our team. You're going to need a truck, so why don't you go get a truck? And I say, okay, but am I really going to get a route? And they say, of course we'll get a route. We don't have any right now, but you'll be on our list and you'll get a route. So I say, okay, well, I'll go buy a truck. But then after I buy the truck, I call up FedEx and they say, you know what, we think somebody else will be better. Why don't we give them the route? Is that a contract? Can I force any contractual rights against FedEx? What do you guys think? No written agreement, a couple phone calls. Any ideas at all? You guys are quiet. I won't be mean if you say the right.
The fact that you went through training and paid for it.
Yes. The answer is yes. That's built off an actual case. The facts are actually worse than that. FedEx was not a very good actor in that case. But the theory is that, as an objective person, I expended sums of money in reliance that what the other person was telling me was going to happen. And so that can create some contractual duties. In the case law, it gets mixed between what's called detrimental reliance and a duty to negotiate in good faith, but fundamentally what you've got is a contractual obligation that FedEx didn't think they had, which is kind of the first problem you need to know when you've entered into a contract. That's not an uncommon fact scenario, unfortunately. There's another case, for example, that had an ice cream store, and the ice cream store wanted to move to a hotel, and the hotel said, this is great, we want you here, we'll negotiate the lease, but the document is just, forthcoming. The ice cream store owner said, hey, my lease at my current space is terminating. They said, again, no problem, we're going to get it done. Terminated negotiations, contract. There's a case out there, this is a little bit iffier, but employment. It can also arise in the context of employment where there's cases that somebody has accepted a job, terminated their existing job, moved, and then the new employer said, no, I didn't really mean to bring you on. Now those cases are a little bit harder because usually employment's at will, so what really are the damages, but there are a number of different cases where this concept of reliance, where you did something thinking that the other person was going to bring a benefit to you generates contractual liability without a written contract. Probably where I see this concept rearing its ugly head most in my practice is with letters of intent. We have a number of clients who understand that they are going to need some help if they sell their business, for example, or into another major transaction, and come to us, but they don't come to us until they've had some negotiations and some writing with the other party. And a lot of times that comes in the form of a letter of intent or a memorandum of understanding. And those can be extremely dangerous because there are a number of cases where the parties, based on entering into those, thought that ultimately it was just kind of a general expression of what we're going to do, but if I changed my mind based on what I found in due diligence, I could back out, or if ultimately, you know, we didn't reach terms on a big definitive agreement, I could back out. But sometimes those are enforced. There's a famous case involving oil companies. I think it was Texaco versus Pennzoil. Getty Oil had negotiated with I think it was Pennzoil, and they had reached basic terms, and Getty had released a press release that said, you know, we've reached general terms. It's going to be subject to a definitive agreement, you know, but you know, expect to be selling. Texaco outbid them. Getty sold to Texaco, and ultimately the court said that that original kind of expression, even though it contemplated a later definitive agreement, really generated contract rights, and they awarded like $8 billion in damages, which was essentially the value of Getty. So you really do have to be careful in those. Another situation where you can run into some trouble is with advertisements. Does anybody remember Pepsi points? Pepsi points, for those who aren't shaking their head, I mean, they ran this campaign that said, you know, if you buy Pepsi, you get points. And if you get the points, you can turn them in for goods. And the advertisement that they had run showed a high school kid that woke up in the morning and threw on some sunglasses, and they said Pepsi points, 50 points or something. And then a jacket, a leather jacket, and they said, you know, leather jacket, 1,000 points. And it just kept going until at the end they showed a Hawker Harrier jet landing in the high school yard, and they said 7 million points. Well, this guy out in the world had this bright idea. He said, well, let me start getting some Pepsi points so I can get my Hawker Harrier jet. Well, it turned out he couldn't drink enough Pepsi, but it also turned out that the program allowed you to buy Pepsi points for a certain sum. So he got a few Pepsi points and then cut a check to Pepsi for $700,000 and said, please give me my Hawker Harrier jet. Surprisingly, or not surprisingly, Pepsi litigated that for a number of years and said, you know, look, you know, ultimately it was not our intent to offer you the right to buy a $23 million jet used for military purposes for $700,000 and a few Pepsi points. And any reasonable person should have known that that was just a joke and not a concrete offer. Lucky for Pepsi, the court agreed with them and not with the guy who sent in the check. But there are other cases where advertising has, in fact, resulted in a contract. For example, there was an older case in Minnesota where a store put out an ad that said something along the lines of 3 fur coats worth $100 each for $1 a piece, first come, first serve. And a gentleman by the name of Lefkowitz showed up. He was the first one at the store the next day. He said, here's my $3, please give me my 3 coats. And they said, for some reason, that no, we won't give you the coats. We intended them to go only to women, and refused to sell them. He turned around and sued them, and ultimately he was successful because in that case, unlike the Pepsi case where, you know, a reasonable person might have determined that they were not, in fact, intending to sell a Hawker Harrier jet worth $23 million for $700,000, that advertisement was concrete and definite and not intended as a joke. And so that was, in fact, an enforceable promise that created some contract rights. So you do have to be careful in that situation as well. Okay, and then once you determine whether you have contract rights, you got to know what it says. That's the whole point of the contract. You know, if you have a writing, that's pretty clear, kind of at least as an initial blush, that you've got in what it says. But yes, Mike indicated, and as I've indicated, you can have oral contracts. Email exchanges can create contracts. Text messaging can create contracts. Just a conversation. When Mike asked me to speak in January at this event, and I said yes, that was a contract. So I think the first important point is get it in writing. You know, that does a couple of things. Number one, it memorializes what the deal is. If you have a conversation about a deal, people aren't going to remember what the deal is. You're not going to be able to prove what the deal is. You're not probably going to spend the time conversing about the details of the deal. So I think the first concept is if you're going to enter into a contract, you do need to get it in writing. Once you get it in writing, though, and somebody gives you a contract, you have to think about what's in it. Anybody ever heard of the Brown M&M case? Van Halen was one of the first bands to take major productions into kind of lower level markets and venues. And they had a very extensive contract that they presented to each of these venues. And one way to think of a contract is as a set of instructions on how you should interact with each other. And that's in essence what theirs were. They had an extensive list of safety precautions, for example. The stage had to support this much weight. The electrical had to work in this particular way. Very detailed. But buried within the contract were a number of very weird and unusual provisions. One of those provisions was that backstage in their dressing room, there had to be a large bowl of M&Ms, and there could not be a brown M&M in the bowl. And they got a lot of flack for that in the press, but when confronted, they said that the reason that they put that provision in is that they used that as a test to determine whether or not those venues had read the contract. Those, if they showed up and there was there wasn't a bowl of M&Ms or there was a bowl with brown M&Ms, they immediately turned around and checked everything. And if it wasn't right, they got up and left, and that clause in that provision gave them the right to leave without any damages. So it's a good way to remember it's important to read your contracts. The other parties expect you to. You need to. The court will not excuse you because you have not read the contract. Just kind of as a side note too, a lot of people in the room probably are in technology and we have click-through agreements. Just as I think the last study I read is, something like 10 or 15% of the people actually read what those agreements say, and maybe even less actually keep them. So, but those are generally enforceable. Parole evidence rule and merger clause. The thing to remember here is if you do reduce your contract to writing, then the courts rely very heavily on what's on the face of that contract. Very often you'll have clients that communicate for a number of days or weeks or months about their business deal, and they may do it orally and they may do it via email. And then ultimately they'll contemplate a written agreement, and they'll get a written agreement put together and they'll both sign it. Then things go on down the road and ultimately something goes wrong and somebody says, hey, wait a second, you didn't do X. And our deal was you would do X. And the other party pulls out the contract and says, well, it doesn't say that I had to do X. And maybe we talked about it, maybe we didn't, but the contract itself does not address this particular issue. Courts are very, very leery to go outside of contracts. The parole evidence rule generally limits the court's ability to move out and look at contemporaneous evidence, be them conversations or emails or other contexts, to determine what the contract means. And so you have to be very careful when you're drafting a contract to make sure that what you want the deal to be is set forth in the contract, and you are not in any way, shape, or form relying on kind of conversations that happened in the negotiations or other things. And that's probably helpful to most contracting parties too, because you don't, if you bothered to read the contract, if you bothered to put the contract in writing and sign it, then you probably don't want to be held to contemporaneous evidence. Once you've signed a contract, many contracts, if they're in writing, contain what's called a merger clause. And that ties into the parole evidence rule. It basically says, this is our writing and we intend it to be final. And the purpose of that is to try to say, this is the deal, and these conversations we had on the side aren't part of the deal. But it's also important to note that you can waive, I don't know if I have, yeah. You can waive rights under a contract, even if you have this provision that says this is the whole contract and nothing but the contract. Your conduct after you've signed the contract can waive it, even if that is oral. The courts are very leery of kind of enforcing these merger provisions that say you should only read the contract. To be more clear, the parole evidence rule kind of prevents evidence before you entered into the contract from coming into the court. But once you've entered the contract and started operating under it, the courts are very willing to bring in evidence to say that you've changed the terms. And they are case after case where they said, well, we can't amend the contract without a writing. We can't waive a term of the contract without the writing. And the court's saying, you know, we read that, we understand it, but in reality, you guys acted differently. You really did amend it. You really did waive it. And so you have to be careful to live up to the terms of your contract. And if you want to change something, put that in writing, sign it, and be clear about what you're waiving, what you're not, what you're amending, what you're not. You also need to be sure that your contract matches your business deal. You know, that just probably goes without saying, but you know, we have a number of people that come in and just really don't spend too much time understanding the deal. And lawyers get a lot of crap for slowing deals down and asking a lot of questions and putting a lot of stuff in writing, but my personal opinion is that it's actually good. At the end of the day, you have to deal with the unexpected in a contract. And lawyers have seen a lot of the unexpected come to bear. And lawyers, if they're good lawyers, need to ask a lot of questions. What about if this happens? What about if that happens? How are we going to deal with that? And what that process does, even though it can be painstaking and slow, is it drags out a discussion amongst the business parties as to what the deal really is. Because business parties tend to think time, price, maybe a couple other things and nothing else. But the world is a lot more complex than that. There's a lot of stuff you need to think about, and if you haven't thinking about it up front, if you haven't reached an agreement with your counterparty up front, that's really when you get into some litigation issues that ultimately can harm you and or your business. You also have to know the law. I cannot tell you how many people have come into our office hours, for example, and said, you know, I've got this great new idea for a business. And it involves this computer program or website. And I hired this guy named Joe to do it. And Joe's, you know, been working on it for 6 months, and I paid Joe $20,000, and we're getting ready to go. And I said, well, do you have a contract? No, I don't. Or, yeah, I do. It's real simple. Joe just said, you know, I'd do a contract for him and pay me $10,000 or $20,000. The problem is with independent contractors, the law takes the assumption that if you hire an independent contractor to do something for you, and they do it, the intellectual property that they produce in connection with servicing that contract is theirs, not yours, unless you agree that that service is a work for hire. And so if you have an independent contractor agreement, you don't know that that's the base assumption of the law, you don't contract for that in your contract, then you have a real problem. You have an independent contractor agreement that really didn't accomplish your services or your needs. So ultimately, you really do need to sit down and you need to know the law. Now, sometimes you're going to have to go to a lawyer to try to get some help with that. Sometimes you can figure it out yourself. You also need to know the context when you're entering into an agreement. And I try to be sensitive to this myself, but some deals are really good deals. And they're such good deals that you need to jump on them, and you need to jump on them right now. And you need to be soft in your contract. You're willing to assume some risk because it is such a good deal. So you don't want to spend 3 weeks putting a contract together. You don't want to produce a 100-page agreement and send it over to the other side. There are other times where it's maybe not such a good deal. And there are some risks that you want to spend some time trying to figure out what they are and how the risk is going to be spread amongst the parties. Depending on your facts circumstance, really drives what your contract looks like and how your negotiations. Another way that context can make a difference, I think, is kind of the other side. If the other side is represented by competent counsel and is a major corporation, you might really want to sit down and spend some time drafting a very detailed and useful contract. If the other side is not very astute at business and isn't represented by counsel, you probably want a shorter contract. Having said that, short contract, long contract, one's not better than the other. It all depends on context. They come with their own risk. You just need to think through the entire picture before you enter into them. Okay, so the next thing you need to think about is what happens if somebody doesn't perform the duties that are set forth in the contract. And the first slide I have here is failure of a condition versus a breach of a covenant. This can make a big difference. These are technical terms. A condition, in essence, is something that has to happen in order for you to get something under the contract. And for example, somebody mentioned a bank contract earlier. It's not unusual for them to say, before we advance the loan, you have to give us X, Y, and Z. Those are technically conditions. A covenant is a little bit different. A covenant is a promise. I hereby promise that in the future I will do X, Y, and Z. So for example, every year I will give you my financial reports until I pay off the loan. That's a covenant, and there's a difference. And it's important to understand the difference. I think it principally ties into what happens if somebody doesn't perform. For example, I'm currently negotiating an agreement with a government authority, where the government authority is giving my client, hopefully, some incentives. And the first conversation, we got their first draft, which is actually their standard contract, very long. And we looked at it and we said, boy, there's an awful lot of covenants in here. And so we went to the state and we said, is this your intent if we don't do these things 3 years from now while the contract's still outstanding? Are you going to sue us and seek money damages because we didn't do what we promised? Or is your intent just to take away our incentive and ask us to repay it? They said, well, clearly our intent is to just take the incentive back. We have no intent whatsoever to sue you under the contract to try to force you to do what you said you were going to do, or to try to claim damages, monetary damages, if you didn't. We said, well, that's fine, but that's not how your contract's written. So we had to redo the entire contract to change covenants that would have bound us and opened us up to money damages for a period of about 7 years to conditions, so that it just simply said if these things don't occur, or we don't deliver this, that we don't get the benefits that we thought we were under the contract. Much better risk profile for our client. Another place that can come into effect is there are several cases relating to technology where you have a license, and the license has a number of provisions, some of which are conditions and some of which are covenants. And there's been a number of cases trying to decide whether a provision is a covenant or a condition in a license. And the reason they do that is if a condition fails in a license, then the license goes away and your use of it is in violation of the copyright or intellectual property rights that the licensor has, and their remedy is not a contract remedy, but a remedy under the copyright laws, which have perhaps different procedures and different monetary values assigned to them. And so it's important to know when you enter these contracts, are you dealing with a covenant, which is a promise to do something in the future that if I don't do, I can be sued under contract? Or is it a condition that simply says, if I don't do this, I don't get the bargain? it makes a big difference in some cases. Types of damages. The standard damage in contract law is expectancy damages. If you enter into a contract with somebody and that person doesn't perform what they said they were going to perform, then you have a right to sue them for breach and try to generally get back your expectancy damages, which are things that you reasonably anticipated to get if they actually did what they said they were going to do. But there are also other types of damages. There are liquidated damages, which are damages that are set in stone up front. There are reliance damages. If you go back to the beginning of the presentation, we had a couple cases dealing with reliance. For example, the FedEx case. In that case, I don't think the court would have awarded my lost profits, which may have been what my expectancy was, but instead would have given me reliance damages, which simply says, I'll give you instead what you spent, to put you back into the position had the other party actually not been bound. I think one of the things you have to remember about damages, I mean, it's not just breach and I win and I get everything I want. You also have to be able to prove up those damages. Anybody watch a movie called National Lampoon, The Pledge? I know I didn't. Apparently nobody did. Because it was Paris Hilton was in this movie, and it did rather poorly at the box office. She got paid a very nominal amount for being in the movie, but entered into a contract where she get paid a significant amount, and in exchange for doing that, she agreed to promote the movie and the DVD. And so the producers were really, since they didn't do so well in the box office, really had hoped that the DVD would do well. So they ultimately asked her to promote in various places the DVD release. They sent her emails. She was supposed to respond within 72 hours. She didn't. She was on vacation in Hawaii and was busy, she said, so she didn't bother. They called her. She ignored them. And so ultimately they lost a bunch of money because the DVD didn't do well, and they sued her. And the court very quickly came to the conclusion that she in fact did breach her contract. But then the debate was, well, what are the damages? The producers wanted all sorts of stuff because in their mind, had she done what she said she was going to do, they would have made a ton of money on the production. But the problem is they couldn't prove it. It's one movie may do well, another movie may do poorly. It's really hard to predict what would have happened if somebody performed. And so ultimately the court didn't award them anything because even though she had clearly breached the contract, they couldn't establish a reasonable amount of damages. That's also something that happens, I think, with new businesses. You don't have a long track record of what your profit's going to be. And so if someone breaches a contract with you that causes you damage, you may have a difficult time actually establishing what those are. The other thing you have to watch out for is attorney's fees. A lot of people think, well, boy, if the other party I'm contracting with clearly and intentionally violates the terms of our contract, then I have to sue on them and I win. One of my damages should be attorney's fees, of course. I would never have had to pay my attorney if, in fact, that other party did what they said. But the law in Iowa and many states is that you cannot collect attorneys. The prevailing party cannot collect attorney's fees unless a statute specifically provides, which it doesn't in the case of contracts, or a contract specifically provides that you get attorney's fees. So don't expect to get fully put back in the position that you would have been, because you're at the very least going to have to pay your attorneys. You also need to know when the contract terminates. There's not rocket science to this. It's just read into the contract, make sure you understand when it ends and how it ends. Although the term of the contract really does affect the negotiations. I think the first thing that I always focus on when I'm dealing with contracts is how long is this contract going to run for? If this is a contract that my client can get out of in 30 days or 60 days, and there's not a pound of flesh associated with that, to be honest with you, I really don't care all that much about what the contract says. If things change, we'll just get out. If we don't like the other party, we'll just get out. On the other hand, if it's a long-term contract and there's not an effective way for me to get out without paying a significant amount of money or incurring an obligation I don't want to, I have to be extremely careful about what the terms of those contracts say. And so I think probably the first place to focus all your effort when dealing with contracts is on how long is this contract going to be. And long-term contracts, you probably really do want to talk to your attorney. You probably really do want to think through what needs to go into the contract and what can happen over the term of the contract. Rolling renewals, you have to be very careful about this. I had a client call me up a few years back. They had a 5-year contract, and it could be terminated within 90 days of the 5-year. If it wasn't terminated, then it went on for another 5 years. Well, unfortunately, they did not know that the 90 days started to run. They let it lapse, and they found themselves in a position where they had another 5-year contract, which would have been great if it was a good contract, but it was a disastrous contract. So you really need to be careful about those terms that roll on. Okay, just a couple of kind of miscellaneous points. With that, I think you, as a business, you obviously need to be organized, and I think it's important to organize your contracts too. Keep them all in a centrally located, organized system. I don't care if it's a locked file drawer or an online database or whatever the case may be, but you need to keep them together. I'm amazed. A lot of my work is actually mergers and acquisitions or investments in companies, and the first thing that happens is the target or the intended company that's getting the investment gets a due diligence checklist. And that due diligence checklist is quite long, and a large part of what is being asked for are contracts. And over again, I'm surprised about how our clients are unable to locate their contracts. Don't really have them in one place, takes them weeks to get them together, they look bad, they don't know the terms, the other side starts to get nervous. You really need to sit down and be able to produce those documents quickly and effectively for another party, but frankly, you need to do that for yourself too, because again, contracts are like instructions. You need to know what they say. You need to know where to find them if you have a question. Also, it's probably a good idea to maintain a database of deadlines and institute a reminder system. Going back to the renewal period, if in fact my client had maintained a database that would have reminded them of that 90 days, they could have avoided that problem. There are a number of products and services on the market that help you do that. You could do it yourself. You can be fancy or not fancy, but I think you need to do it. You need to know when you have a delivery under a contract. And that's not just the renewals or the terminations either. I mean, I have contracts that have delivery obligations within them. And so when those delivery obligations arise, you don't really want the other party to have to remind you to do it. You don't want to be in breach of the contract by not having provided what you're supposed to provide. So you just need to docket these things and understand when they're coming up and how to address them. As I said, you need to be cautious with long-term contracts. You also need to be careful of those that contain indemnification provisions. A lot of contracts contain indemnification provisions. I put them in a lot of my contracts. An indemnification provision basically says, if I receive a loss, my contracting party will make me whole or hold me harmless. And that's a good thing in many cases. My problem is, number one, people don't think about them. They shift risk of loss within the contracts on the things that they cover. That risk of loss may be, for example, pushed beyond insurance. So the party that has the insurance is the one that is getting indemnified. The one that's indemnifying or paying the loss is the one who doesn't have insurance. You just need to think through them. I think in the most cases they're sloppily drafted, and you just need to think through what they mean and how they work. You need to be careful about those contracts that contain provisions that could limit your ability to operate your business. Non-competes, you really have to be careful about non-competes, confidentiality, and other provisions because they can be a real problem. Putting it in context of a business organization, a manager of an LLC, a member of an LLC, if it's member managed, a director of a corporation, they have fiduciary duties to not engage in similar businesses with those that they already have a relationship with, unless you contract around that duty and say that it's okay for them to do this or to do that. You need to watch out because you can really kill your business through a contractual right that you're not thinking about. You have to watch out for personal guarantees. Everybody sets up businesses when they are entities that have these liability shields, be them LLCs or corporations. But in a number of cases, you're not signing on behalf of the entity itself, but you're signing in your personal capacity as a guarantor. When you sign a contract for a business entity, you want to be clear, first of all, that you're signing as an agent of that entity and not in your personal capacity. And that's covered by the signature block and just making clear what capacity you're acting in. But there's also many contracts that have personal guarantees. I haven't come up against this, but I was having lunch with a client the other day who was telling me that it's regular practice, for example, in the construction industry, when you go in and you buy goods and services from the lumber yard, and you're going to pay on terms, that you just sign their form and give it to them, and you take the materials and you go out. Just so happens that apparently the forms say whoever signs hereby personally guarantees. So I immediately think of my brother who works for a construction company, and wouldn't this be great if he goes to the lumber yard and buys some stuff for work, signs the contract, takes it out, his employer goes bankrupt, he can't pay it, and now my brother's on the hook. You need to look for personal guarantees that can be buried everywhere. Another thing to remember is contracts are complex. You can have a single word that could harm you significantly. Here's a case where it's a buy-sell agreement. And the buy-sell agreement essentially said if somebody wants to sell, then they have to first offer their interest to the other party. And the other party has the right to buy it. It's a right of first refusal. It's very common in buy-sell provisions in closely held companies, so you can keep track of who owns it. You don't want your competitor acquiring an interest in your business and becoming your partner. The problem is this particular buy-sell didn't require the purchaser to buy all of the other party's interest. It said it could buy any of the other party's interest. So the other party bought one share for a nominal amount and acquired control of the company and essentially took over everything, completely killing the benefit of the deal for the other side. So one single word can really be a problem in a contract. You really have to think through and read the agreements. Choice of law and venue can be important. Contracts, there's default rules on what law is going to apply, and if you have a dispute where you're going to hear that, any sort of lawsuit, but you can contract around that to some degree. For example, if you have to be careful with this too, because first of all, if you agree to a venue, that's where the lawsuit will be heard in somewhere else, like if you're in Iowa and you agree to New York as the venue. That could add a lot to your expenses. You have to fly people to New York, you have to spend time in New York, and so you kind of want to avoid that if you can. You also have to worry about choice of law because it can vary from state to state what the rules of law are. Kind of the worst case scenario that I've seen on this is I had a client a few years back who unfortunately had agreed, it was a technology company, they entered into a contract with an Indian tribe, and they agreed to have the tribal law govern their contract. And they agreed to venue in the tribal courts. Well, they didn't perform what they were supposed to do under the contract, and so the tribe started exercising its rights. The only problem was the tribe really didn't have any body of law and was simply making it up as they went along, which obviously was always in their favor. And so you really need to sit and think about choice of law provisions as well. You need to think about disclaimer of warranties, limitations of damages. These are standard in contracts. And they're good ideas if you're the one selling the good or service in some respects, but they're also bad ideas sometimes. When you see them, you have to stop at least and think, why is this person that I'm dealing with not willing to stand behind their good and service? Why are they trying to limit their damages or their liability? They may have very good reason, but you at least have to stop and think about it. Probably more important than anything is you have to know who you're dealing with. Going back, I talked about the Paris Hilton case. There's a surprising number of contract claims against Paris Hilton. I would not enter an agreement with her necessarily, but you really need to think about who this other person is. If you've gone through and you've drafted the world's most perfect contract, if the other party isn't a person who is going to stand by their word or even going to be able to perform, you really haven't gotten the benefit of your bargain. So more than anything, you need to start with dealing only with people that you trust. You also have to look out ultimately for assignments, because this happens all the time, if you're dealing with somebody, you vet them, you say, I really like you, I trust you, this is a business that has a long history and a lot of capital, and so I'm comfortable entering into a deal with them. If the contract says that they can assign their rights and delegate their duties whenever they want to, then they could simply push all the liability on the contract to a subsidiary that doesn't have a lot of assets, or they could send it to a competitor that you don't want to be doing business with. So you really have to watch out for those. So I think that's it. Any questions? Got 2 minutes if you do.
In some contracts, they'll stipulate a choice of law, either arbitration or legal action. Why would they go to arbitration or make that choice available?
There are different reasons that people use arbitration. Credit card agreements and a lot of financial institutions use arbitration. And I think principally in that sense, they're trying to reduce their cost and reduce the risk of class action lawsuits. But in other cases, people like arbitration. In many states, the courts are backlogged, and it's very difficult to get your dispute resolved in a timely manner. Arbitration is a private system that allows you to resolve usually a lot quicker, and so some people like that avenue. Now, I personally am not a fan of arbitration because of a few reasons. Number one, Iowa's courts are actually quite quick, and they're good, and I don't see why I need to go outside of them. Number two, Iowa's courts aren't that expensive. Arbitration, you have to hire the judge, and you have to pay for them, and you have to pay the fees. For example, I had an arbitration issue a few years back. I think the amount of dispute was like $1 million, and my client had to pay $6,000 or $7,000 just to file the arbitration, and then they had to pay the arbitrator, $300 or $400 an hour. None of those fees would have been incurred if they had just simply gone down the court route. But having said that, there are some benefits to arbitration. You can talk to 10 lawyers and they'll come up with 10 different ideas about whether arbitration is a good idea or a bad idea. Personally, I don't want to use it that much. I guess the other thing about arbitration is with a court, I know what the rules are. I know the rules of evidence. I know the rules of discovery. I know that they're going to render a reasoned opinion in writing at the end that I can appeal. With arbitration, the rules are because it's intended to be fast, very vague, unless you write them in. And frankly, by the time I write in rules I'm comfortable with, they look a lot like the rules of civil procedure and evidence that apply. Other questions?
In keeping your contracts, is it okay to scan your contracts and keep just a digital copy of it?
Yes and no. There's a thing called the best evidence rule. And the best evidence rule provides that you need to Oh, sorry, thank you. I need to repeat the question. The question is it okay to simply retain a digital copy of the contract as opposed to an original signed paper copy, right? Okay, and the best evidence rule says that you're supposed to, if you go to court, produce as evidence the original. And so in that regard, it would say, no, it's not sufficient to keep a digital copy of the contract and discard the original. Having said that, an original is defined to include copies if intended to be an original. So you'll see at the back of a contract, oftentimes, a provision that specifically says, we may sign more than one copy of this contract, each of which is intended to be an original. Or we may exchange the contract via PDF or facsimile, and those are intended to be originals. So it really depends. I think as a matter of course, you probably should keep the originals. But frankly, if you draft your contracts correctly, you can probably get away with just a copy. And there's exceptions to the best evidence rule. If you can't find the original, if the other party has the original, you can get yours in evidence. But there are some resistance and things that you might get into fight about that cost you extra money in litigation if you don't have the original. One more and then quit if there is one more. No? Okay, well, thanks. Hopefully I did address your questions and taught you a little.
Thank you.